Hello, today is Tuesday, July 7th, 2020. I'm Joe Schmidt from TC2, and this is Staying Connected. These continue to be crazy times, but fortunately, the global economy is starting to show signs of improvement, and businesses are starting to reopen. Let's hope this continues. Longer term, one thing is certain. Company mergers and acquisitions will always be a fact of life. M&A is probably more common in industries like pharmaceuticals, banking, insurance, and technology, but it could happen in any industry. If you work for a company that's merging, what do you do when two ICT contracts exist for the same supplier and or the same services? What do you need to know? And more importantly, what do you need to do once the work trickles down to the IT team? To answer these and many other questions on what to do when your company merges, I'm joined by a couple of my colleagues that have dealt with this over the years and have the right answers. For this two-part podcast series, I'm joined by Laura McDonald, a partner at LB3, and Pat Gilpatrick, a fellow director at TC2.
Thanks, Joe. It's good to be here.
Yes, thanks for having both of us. It's a really important topic to understand because you don't want to be playing catch up on the IT side if your company's getting ready to merge with another company.
So, Pat, why don't you continue with that thought? What do you mean by playing catch up?
Well, first of all, every merger and acquisition situation is different. It's always an individual case basis process based on who's consolidating and the sizes and the service mix of both the deals. There's a big difference between a large multinational corporation buying a small company, a David and Goliath kind of scenario, versus two large corporations merging like Charles Schwab buying E-Trade. So once the merger is announced, you cannot wait to start your planning.
And there are parallel approaches needed in an M&A scenario, right? There are legal issues and there are business issues. So I guess since Laura is a lawyer amongst us, maybe it would be useful, Laura, if you first set the stage from a legal perspective.
Certainly. Joe, first, before you do anything, you have to work with your Office of General Counsel to make sure that any review of contracts or data or sharing of contracts or data do not put you at risk of an antitrust violation or other breach of law or contract. In most cases, sharing telecom and information technology information is on the lower side of risk, but as Pat said, it's often ICB, and sharing information during the pre-merger process does require very careful maneuvering. You have confidentiality provisions and agreements. These may limit what you can share pre-merger. You need to check to see if there are carve-outs from merger or acquisitions or to share with counsel or consultants. Make sure you check those before you share. Also, merging parties must avoid creating antitrust liability, particularly with regard to the exchange of competitively sensitive information during the merger due diligence.
Yeah, what we see all the time when companies have announced they're going to merge is a requirement that they still operate as separate legal entities based on a formal M&A timeline.
And there are good reasons why that's the case. Antitrust laws require that parties to a transaction continue to act as separate and independent companies until the transaction closes. However, it's expected that there will be information shared as part of the due diligence and to assist in the transaction planning. But there's a limit to what is allowed. And Pat, as you pointed out, the facts impact the actions. For example, Hart-Scott-Rodino Act, the HSR, provides that for certain mergers, parties must make certain filings and remain separate companies prior to closing, and until the HSR investigation is closed, they cannot combine their operations or hold themselves out as a single company, and the buyer cannot begin to control the business activities of the seller. So you have to make sure your exchange of information does not run afoul of those restrictions or give the perception you're running afoul of those. If you're sharing information, the facts of the merger drive the level of caution needed. You must determine what you reasonably need and whether any of it is sensitive competitive information and set up a protocol and then follow that protocol. Even in very sensitive cases, you can often share by using clean rooms or clean teams, which allow trusted advisors, usually outside legal counsel or consultants, to review the documents. And although I keep talking about antitrust, it's not just the antitrust laws that create the caution. Other laws may limit your ability to share. For example, in most instances, you're not going to be sharing personal identifiable information, PPI, but in some cases, contractor data that you need to review will include it, and in which case you must be very cautious to be sure that sharing the information is in compliance with the myriad of state, federal, and global laws. In short, check with your counsel first.
Okay, so once the ground rules are established on what can be shared, what happens first on the business and commercial side?
Well, once the contracts can be shared, a comparison process should start. The most important issues are the things like timelines and commitments in each deal. How much term is remaining? And are there any things like unpaid credits? Are there contingencies for them? What are the commitment levels in each contract, and how are the two businesses performing toward those commitments? What happens at the end of the term is also very important to understand for any potential service migration or termination liabilities. Some contracts may have severe financial penalties for shortfall or term expiration, like your discounts on your services dropping off. Others may have a transition period where rates are protected for a period of time with no ongoing commitments. Or they could simply revert to month-to-month rates. Some contracts automatically renew for another term period if they're not notified, and that could be very problematic. Lastly, the parties need to evaluate or project any performance impact of the consolidation on any existing commitments to assess the potential risks or liabilities of underperformance based on the remaining timeline or anticipated consolidation of their locations or their services.
So, Laura, what happens from a legal perspective?
From a legal perspective, as you review your contracts, you need to look for any red flags. For example, as Pat notes, there may be incentive-based pricing or credits based on certain conditions that you can't meet as a combined entity, and thus you could lose. That would impact your pricing or even your compliance. You need to look for provisions, and these can either be in the contract or in the applicable service guide, that state that all or a large percentage of the services, including that of your affiliates, must be purchased from the vendor, or that vendor is required to manage all services. Disputes. There may be ongoing disputes where the vendor or the entity you're merging with or acquiring potentially owes money, and there are timelines to those disputes that have to be met. You don't want to lose track of those. You need to be aware of those from the start. And then if there are any spectrum licenses or towers, this is something that's often overlooked. You need to find that out up front because there are certain requirements for the FCC for transferring of those licenses, and there are financial penalties if you don't meet that. So you don't want to run into noncompliance problems with the FCC. You also want to look out for helpful clauses, such as those that give you certain merger rights or allow you to terminate without liability as part of an upgrade. If you're planning on consolidating, you may have a lot of smaller services you want to consolidate into a larger one, and it may be that you can avoid termination by replacing the circuit supports with higher capacity.
All right, so clearly companies have a lot of work to do to make sure that the merger delivers the value that they're expecting. So why don't we pick up in part 2 with what enterprises should do after the contracts have been reviewed. In the meantime, if you do have questions about what you need to be doing if your company is merging, or if you have other ICT lifecycle needs, feel free to contact Laura, Pat, me, or any of the LB3 and TC2 professionals that you work with by dropping us an email or giving us a call. You can also stay current by subscribing to Staying Connected, checking out our websites, or by following us on LinkedIn.